Welcome to Hull & Estates and Succession Planning, a series of podcasts hosted by Ian Hull and Susanna Popovic-Montag. The podcast you are listening to will provide information and insights into estate planning in Canada. From the offices of Hull & Hull in Toronto, here are Ian and Susanna.
Hi, and welcome to Hull & Estate and Succession Planning. You're listening to, and some of you watching, it's episode number 184 on October 27, 2009. Hi, I'm Ian Hull, and I'm going to do this podcast alone today. Susanna is not well with a bad cold, and we thought we would try to keep up to date with our podcasting. Didn't want to miss a beat if we can. So I want to talk about a couple of things and where we have been working from in our Power of Attorney series, and that is staying focused on the question of capacity. It is the fundamental issue. It is the one that Justice Quinn back in 1994 in the Koch decision reminded us of the importance of it and the need for stringent and careful assessment as to one's capacity. Because again, it is the ultimate in taking away of one's liberty. And that is, if you make a finding of incapacity and you appoint a guardian or you allow a power of attorney to prevail in that context, you have taken away that individual's liberty. So I thought we'd step back and look at this question of capacity and a little bit of historically. And where it has come in handy is that really what we are always proud of is our webpage at hullandhull.com. And on that webpage we have continuing series where we go and we have our breakfast series, which we run through webinars and so forth. Our next one's coming up in January. But I went back to the webpage and noticed one of our last broadcasts, the archived breakfast series under the news and events section. And by the way, we're in the process of even revamping our webpage further. So later in the fall, we're going to have a new look and a hopefully a little easier way of navigating in it. But I was struck by the fact that we have in the past dealt with this issue of capacity in what I think, to modestly, is a really effective way of trying to sort of explore the various parameters of capacity. And in my last breakfast podcast, I actually spoke on a series of cases. There's a paper on the web, and there's also a video content of my presentation. I'm not going to be repeating that extensively, but if I encourage you to go look at that. That was the June 9, 2009 breakfast series. But I do want to talk a little bit about some of those cases that we talked about that day, because again, it helps us sort of step back and deal with the whole question of capacity. Now, before we go to that, I've sort of set you up, and we've got a good resource I hope that'll start you to. We have lots of other information on our webpage and our blog in terms of capacity issues, but I thought I would like to go back to my source that I'm really enjoying working through. And again, thanks to Mary Stokes at Leg & Leg for telling me about this book. It's called Dead Hands. It's by Lawrence Friedman, and it's a social history of wills and trusts and inheritance law. So, stepping back and looking at the question of lack of capacity, I go to the author's wonderful quotes here, and he describes lack of capacity as follows. Lack of capacity means either that you are too young to make out a will, or are, to put it bluntly, too arranged or demented to do so. Now he's dealing with, of course, capacity to do a will, which we've talked about before, is a higher level of capacity, many of the authors say, than to do a power of attorney. But the question of capacity is a very similar theme, and some of the same components can be imparted from the test for will challenges as with the test for power of attorney. He goes on to say, too young is almost never a grounds for a contest, but the statutes typically say that you have to be an adult to execute a will. In Georgia, for some reason, a person is mature enough to make out a will before he or she is mature enough to marry or drive a car. Under that statute, anybody 14 years of age can make a will or older. And he goes on to say, though, insanity and dementia are another question. Most testators are elderly, and many are wretched, he calls it wretched health, and are of sometimes insane or demented. Insane delusions sometimes play a part. So I wanted to just touch on this question of insane delusions because I deal with it in my podcast that I've referenced you to. Because again, it comes back to the question of making sure when we assess, even in the context of a power of attorney, that we have done what we need to do. And that is take careful stock of the current circumstances of the individual testator. So one of the themes that I worked up during my presentation the last time around was looking at the global scope of capacity and how it's being addressed in some of the recent case law. And I talk about the definition of insane delusion. Now there's a stark demonstration and illustration of capacity sort of gone awry at its widest scope. And a definition of insane delusion is a belief of things as realities which exist only in the imagination of the patient. So persistent belief in facts which have no real existence. And I think that allows us to step back when we're testing capacity in for a will or power of attorney to truly look at our situation, look at the individual, come back to the same kind of questions, the old adage of ask the same question 3 minutes later, 5 minutes later, to make sure that long-term and short-term memory are being tested. But in this scenario, look to what might seem as bizarre facts and start to delineate whether or not those bizarre facts are just eccentric comments or do they fall into the category of insane delusions. Because if they're insane delusions, the case law is clear for a will, and obviously with power of attorney for property and so forth, tremendously relevant if we have an individual who is suffering from insane delusions. And we've talked about the different delineations, and where I thought we'd try to wrap up my comments today was we talked about earlier the question of undue influence being something between proper influence or influence and coercion and undue influence, and that delineation. Well, the same thing goes with insane delusions. We need to make sure that we've tested, and I always want to make sure if I'm getting bizarre responses or bizarre behavior from my client, I make sure that this isn't eccentric, rather it is maybe demonstrating insane delusions, or as the definition says, persistent belief in facts which have no real existence. Now, I talk about the cases in detail in my presentation in the breakfast series, the Hicks decision and the Bryden decision. And in the Bryden decision, it really is the British Columbia Supreme Court talking about psychotic delusions when testing testamentary capacity. And in that case, the court reminded us, look at all of the surrounding circumstances. Make sure you've tested the individual involved, what their surrounding circumstances are. And in the Bryden case, what was relevant was this individual who was under a disability, had some mental frailty already. The court wanted to make sure that the delineation between insane psychotic delusions was not was indeed the case, and that we weren't dealing with what was an eccentric individual who had maybe what might be described as unique understandings of how his or her, in this case, how her estate should be cared for, so and distributed. All right, so this has been a bit of a solo attempt here. We much miss Susanna or a partner on the other side to at least have some engaging discussions, but I think at least we've touched on what come back to the paramount concern whenever we're dealing with capacity scenarios, that we get it right, and that we're always thinking of the benefit of the individual and capable person, so that it is in their best interest to maintain that goal, so that we are determining whether this person is indeed capable or not capable, with keeping our eye on the ball of what the Act in Ontario and all of the other acts say, and that is, when you're dealing with an incapable, primary job one is to make sure you're protecting the incapables and you're adding benefit to the incapable's life in your efforts to come to court. So those are my thoughts today. I welcome you. Next week we'll have Susanna hopefully back, and I welcome any of your comments. Please feel free to go onto the webpage at hullandhull.com, and thank you very much for joining us this week.
You have been listening to Hull & Estates and Succession Planning by Ian Hull and Susanna Popovic-Montag. The podcast that you've been listening to has been provided as an information service. It is a summary of current issues in estates and estate planning. It is not legal advice, and you're reminded to always speak with a legal professional regarding your specific circumstance. To listen to other Hull & Hull podcasts or leave any questions or comments, please visit our website at hullestatemediation.com.